Donald Trump wasted no time implementing his hardline immigration policies, sparking fierce opposition from churches and religious groups. Now these organizations are fighting back, filing lawsuits against the administration for violating their religious freedom. On his first day in office, the Department of Homeland Security revoked the long-standing sensitive locations policy. For decades, this policy had generally restricted U.S. Immigration and Customs Enforcement, ICE, from carrying out enforcement actions in places like churches, hospitals, and schools, except in cases of immediate threats to public safety or national security. The policy was based on the principle that essential activities, such as medical care and religious worship, should remain accessible to all, regardless of immigration status. Without these protections, undocumented immigrants are now at greater risk of being arrested, even in places of worship. But the consequences extend beyond individuals. Churches that view welcoming undocumented immigrants as a core tenet of their faith now face an impossible choice: uphold their religious beliefs or comply with the law. That's where this lawsuit comes in. A coalition of 27 Jewish and Christian religious organizations, representing national denominations and interfaith associations with millions of members, has sued to reinstate the sensitive locations policy. Their goal is to prohibit immigration enforcement in places of worship unless there are urgent circumstances, arguing that the government's actions violate the Religious Freedom Restoration Act. Enacted in 1993, RFRA grants religious exemptions from federal laws. It prevents the government from imposing a substantial burden on a person's religious practice, even under broadly applicable laws, unless it can prove that the restriction is the least restrictive way to achieve a compelling government interest. RFRA has long been a favorite among conservatives. In fact, two major conservative legal organizations, the Alliance Defending Freedom and the Becket Fund, were founded in its wake to litigate religious freedom cases, often on behalf of evangelical Christians. The law was central to Burwell versus Hobby Lobby, in which the Supreme Court ruled that the Affordable Care Act's contraception mandate violated the religious rights of Hobby Lobby's evangelical owners. RFRA is also a frequent go-to for the Supreme Court's most conservative justices when dissenting in cases that expand LGBTQ rights. Time and again, Christian litigants have invoked RFRA to seek exemptions from laws protecting reproductive freedom, LGBT rights, and other policies they oppose. However, RFRA has also been successfully used by other religious groups, including in cases involving immigrants. In 2020, a federal judge overturned the convictions of 3 Unitarian Universalist church members who had been arrested for leaving food and water for migrants in the desert. The court ruled that their actions were an expression of their sincere religious beliefs and that prosecuting them violated RFRA. Because RFRA cases hinge on proving that a law burdens the sincere exercise of religious beliefs, the 27 religious groups suing to reinstate the sensitive locations policy devote much of their complaint to demonstrating that caring for immigrants is central to their faith. They cite religious teachings that emphasize welcoming strangers, an idea deeply rooted in the Torah and the Christian Gospels. They argue that their faith teaches that all human beings are created in God's image and therefore deserve care and dignity. As members of God's kingdom, they reject hierarchies based on race, language, nationality, or legal status. The lawsuit also details the broader community services these religious groups provide, such as food distribution and preschools, emphasizing that such outreach is a fundamental part of their faith. In a particularly strategic move, several plaintiffs argue that their religious beliefs require in-person worship, an argument that conservative churches successfully used in RFRA-based challenges to COVID-19 stay-at-home orders. In simple terms, the plaintiffs argue that allowing ICE to arrest immigrants in houses of worship places a significant burden on their ability to practice their faith, which requires them to serve and protect all people. If they continue supporting undocumented individuals, they risk exposing them to ICE, violating their religious duty to provide care and sanctuary. If they stop offering support, they would also be betraying their faith's core principles of hospitality and compassion. Several plaintiffs have already reported harm. Attendance at services has declined due to fear of ICE. Clergy members are diverting time from ministry to find ways to protect undocumented congregants, and fewer community members are using essential services like soup kitchens. Legally, this should be a clear victory for the plaintiffs. They have demonstrated that their faith has long required them to actively protect immigrants, worship together in person, and serve their communities without discrimination based on legal status. But if ICE is allowed to enter places of worship and make arrests, it undermines the very sanctity of these spaces, turning them from places of refuge into places of fear. The government has yet to file a response in this case, but its argument will undoubtedly be that arresting undocumented individuals is such a compelling interest that it outweighs the plaintiff's right to practice their religion. However, any claim the Trump administration puts forward will be rooted in the false narrative of a border invasion by dangerous criminals. Even if a court accepts that argument, the plaintiffs should still prevail. That's because the government must prove that its actions, such as sending ICE agents into a church to make arrests, are the least restrictive way to achieve its stated goal. That will be a difficult case to make. The now rescinded sensitive locations policy already included broad exceptions that allowed ICE agents to act in urgent situations. Under that policy, ICE could still enter houses of worship to make arrests if there was an imminent risk of death or harm, a national security threat, or the potential destruction of criminal evidence. They could also act if they were in hot pursuit of someone who had just crossed the border or posed a public safety threat. In other words, the policy already accounted for any emergency scenario the administration might cite. Ultimately, no one can predict how the courts will rule when the deeply held beliefs of millions collide with an administration intent on instilling fear in immigrant communities. But if past RFRA rulings hold any weight, these religious groups should have the right to practice their faith freely, including the fundamental duty to welcome and protect strangers.